the Libel and Slander Act. Let's read through this act. Now remember, any comments I make is not legal advice. In fact, I'm not an attorney at law. This is an act by the Jamaican Parliament, and as Jamaicans, let's read through this act and discuss it. Now, based on information I found online, to libel and slander, both libel and slander, means to spread false information that damages somebody's character, somebody's good name, somebody's reputation. To libel means to put that information in writing, and to slander means to speak that information. So these are the arrangements of sections. (1851), and this is saying that the latest update to it was in 1969. Section 1, short title. This act may be cited as the Libel and Slander Act. Part 1, defamatory words and libel. Section 2, apology admissible in evidence in mitigation of damages. In any action for defamation, it shall be lawful for the defendant, after notice in writing of his intention to do so duly given to the plaintiff at the time of filing or delivering the plea in such action. Remember, the plaintiff is a person complaining who takes legal action, and the defendant is the person who is being sued, defending themselves. All right, so in any action for the defendant, it shall be lawful for, in any action for defamation, it shall be lawful for the defendant to give in evidence in mitigation of damages that he made or offered an apology to the plaintiff for such defamation before the commencement of the action, or as soon afterwards as he had an opportunity of doing so, in case the action shall have been commenced before there was an opportunity of making or offering such apology. So somebody libels or slander you, you can sue them, force them to make a payment, or you can demand that they apologize instead of having them pay the money. All right, so they have the chance to apologize, and if they don't, then you can force them to pay money to cover damages. All right. Section 3, in action for libel in a newspaper, what defendant may plead. In an action for libel contained in any public newspaper or other periodical publication, it shall be competent to the defendant to plead that such libel was inserted in such newspaper or other periodical publication without actual malice and without gross negligence, and that before the commencement of the action or at the earliest opportunity afterwards, he inserted in such newspaper or other periodical publication a full apology for the said libel, or if the newspaper or periodical publication in which the said libel appeared should be ordinarily published at intervals exceeding 1 week, had offered to publish the said apology in any newspaper or periodical publication to be selected by the plaintiff in such action, and every such defendant shall, upon filing such plea, be at liberty to pay into court a sum of money by way of amends for the injury sustained by the publication of such libel, and such payment into court shall be the same effect and be available in the same manner and to the same extent, and be subject to the same rules and regulations as to payment of costs. So far, this seems to be saying that you can have settlement out of court, right? And it will be considered to be remedy, just as if the payment was made in court. I'll continue. As payments of money into the court in personal action under the rules and practice of the Supreme Court, and that to such plea, to such action, it shall be competent to the plaintiff to reply generally, denying the whole of such plea. You see how long this sentence was. Section 3 is one long sentence while they really write these documents. Alright, section 4. If any person shall publish or threaten to publish any libel upon any other person, or shall directly or indirectly threaten to print or publish, or shall directly or indirectly propose to abstain from printing or publishing, or shall directly or indirectly offer to prevent the printing or publishing of any manner or thing touching any other person, with intent to extort any money or security for money or any valuable thing from such or any other person, or with intent to induce any person to confer or propose for any person any appointment of or office of profit or trust, every such offender. So this is talking about somebody who threatens to spread information or to withhold some good information that might benefit you, unless you pay them money or other things, right? Or you apply for a job or promotion and they threaten to publish information about you, and if that information is published, then likely you will not get the job or promotion, right? That is the offender. Every such offender, on being convicted thereof, shall be liable to be imprisoned with or without hard labor for a term not exceeding 3 years. So that's extortion, right? Provided always that nothing herein contained shall in any manner alter or affect any law now in force in respect of sending or delivery of threatening letters or writings. Section 5. If any person shall maliciously publish any defamatory libel, knowing the same to be false, every such person being convicted thereof shall be liable to be imprisoned for a term not exceeding 2 years, and pay such fine as the court may impose. So they know that the information is false, but they still publish it. Alright, section 6. If any person shall maliciously publish any defamatory libel, so section 6, publish any defamatory libel, every such person being convicted thereof shall be liable to fine or imprisonment, or both, as the court may impose, such imprisonment not to exceed a term of 1 year. And this is malicious defamatory libel. Section 7. Proceedings upon trial of indictment for defamatory libel. On the trial of any indictment or information for a defamatory libel, the defendant, having pleaded such plea as hereinafter mentioned, the truth of the matters charged may be inquired into, but shall not amount to a defense, unless it was for the public benefit that the said matters charged should be published, and to entitle the defendant to give evidence of the truth of such matters charged as a defense to such indictment or information. It shall be necessary for the defendant, in pleading to the said indictment or information, to allege the truth of such matters charged in the manner now required in pleading a justification to an action for defamation, and further to allege that it was for the public benefit that the said matters charged should be published. So they seem to be saying that the information published will benefit the public. Anyway, continue. And the particular fact or facts by reason, whether it was for the public benefit that the said matters charged should be published, to which plea the prosecutor shall be at liberty to reply generally, denying the whole thereof, and if after such plea the defendant shall be convicted on such indictment or information, it shall be competent to the court in pronouncing sentence to consider whether the guilt of the defendant is aggravated or mitigated by such plea, and by the evidence given to prove or disprove the same. Alright? Provided always that the truth of the matter charged in the alleged libel, complained of by such indictment or information, shall in no case be inquired into without such plea or justification. Alright? Provided also that in addition to such plea, it shall be competent to the defendant to plead a plea of not guilty provided also that nothing in this act contain shall take away or prejudice any defense under the plea of not guilty, which it is now competent to the defendant to make under such plea to any action or indictment or information for defamatory words or libel. Section 8, Prima Facie case of publication by agent may be disproved. So prima facie, meaning on the face of it, as it appears immediately. Alright, we read section 8. Whensoever, upon the trial of any indictment or information for the publication of a libel under the plea of not guilty, evidence shall have been given which shall establish a presumptive case of publication against the defendant by the act of any other person by his authority, it shall be competent to such defendant to prove that such publication was made without his authority, consent, or knowledge, and that the said publication did not arise from want of due care or caution on his part. Also, this seems to be saying that if your employee or somebody who you are supervising went ahead and made the publication of libel and slander, and you did not know, you had no idea that that was to be done, and they did this despite you being careful. You exercise all due care, and that other person went behind your back and do it. It might seem that you are the one who sent them to do it, but if you can prove to the court that they were the one who took action, maybe disobeying your orders or acting without your knowledge, then you would not be considered to be guilty of libel and slander. That seems to be what this is saying. Anyway, section 9, costs. We're going to read section 9 on cost in another video. Alright? So let's look at that in a different video.